All right, let's jump right in. Today, we're taking a trip back in time to look at a really specific law from the era of British India. It's called the Police Incitement to Disaffection Act of 1922. And, it was designed to do one particular job, and the way it was written is, well, it's pretty fascinating. So here's how we're going to break it down. We'll start with a bit of historical context, set the scene. Then we'll dig into the main event. What exactly is the crime of disaffection? From there, we'll cover the penalties, and maybe most importantly, all the exceptions, the things that were not considered a crime. And finally, we'll wrap up with a quick look at how these cases were actually handled in court. So first things first, let's get our bearings. This act was officially passed on October 5th, 1922. We are talking about a law that is literally over 100 years old now. It was created in a political world, a social landscape that was completely different from today. And it's really important to keep that in the back of your mind as we go through this. Which, of course, brings us to the big question for this whole explainer. What does this law actually do? What does it prohibit? And why was it even created in the first place? Let's get into it. Okay, first up, let's try to understand the basic mission of this act. What was its purpose? What was it fundamentally trying to achieve? Well, the law itself is super direct about it. Its official purpose is right there in the text, to provide a penalty for spreading disaffection among the police. Now, that word, disaffection, that is the absolute key to this whole thing. It basically means trying to chip away at loyalty, or to make someone feel hostile towards the very government they're supposed to be serving. And who exactly was this law designed to shield from that disaffection? Well, Section 2 defines a member of a police force in really broad terms. It's not just one group. It covers pretty much anyone who is officially appointed or signed up for police duties under a whole list of other laws. So, now we get to the real heart of it. Section 3. This is where the law lays out what the actual crime is. And here it is, the original legal language. And yeah, it's a bit dense, but it's also incredibly specific. You'll notice words like intentionally causes, attempts to cause, or induces. It's all about trying to get an officer to turn against the government, stop doing their job, or just break the rules. Okay, let's boil all that legal jargon down, right? The crime really comes down to three main actions. Number 1, you try to make a police officer disloyal to the government. 2, you try to convince them to just stop working. And 3, you encourage them to break their own internal rules, their own code of conduct. It's all about that active effort of causing or inducing these things. Okay, so that's the crime. The next obvious question is, what happens if you get caught and convicted of doing it? What were the stakes? The penalties were pretty straightforward. If you were found guilty, you could be looking at up to 6 months in prison, a fine of up to 200 rupees, and you have to remember that was a lot of money back in 1922. Or you could get hit with both. But, and this is where it gets really, really interesting, this law wasn't just a simple hammer. It actually has some fascinating exceptions built right in. Loopholes, you could say, that draw a very fine line between illegal incitement and protected speech. And this slide, this nails that distinction perfectly. On one hand, you have disapproval that's likely to cause that disaffection we talked about. That's illegal. But on the other hand, you were allowed to express disapproval if your goal was to get things changed through lawful means. See the difference? It's all about your intent and how you go about it. Criticizing to improve things legally was fine. Criticizing to make police disloyal was not. And there's another major exception here. If you were acting in good faith to try and make things better for a police officer, promote their welfare or look out for their interests, that wasn't a crime. This could even cover encouraging them to withhold their services, but only if it was done in a way that was already authorized by the law. The act also had specific protections built in for what we would now call police unions or associations. But for their actions to be protected, they had to check 2 boxes. First, the association itself had to be officially recognized by the government. And second, whatever they were doing had to be in line with their own government-approved rulebook. So finally, let's just quickly touch on the process. How did the justice system actually handle someone who was accused under this act? Now, this is a really big deal. A case couldn't even get off the ground without getting permission first. You needed a sanction or an official green light from a very senior local official, like a district magistrate or a city's police commissioner. This was a pretty high bar, designed to stop frivolous cases. And if a case did get that green light, the trial itself had very strict rules. It had to be heard by a senior judge, a presidency magistrate, or a magistrate of the first class. And these cases could not be tried summarily, which is a legal term that basically means they couldn't be rushed. They required a full, formal trial. And just remember the sheer scope of this thing. The law schedule lists a ton of different police forces it applied to, from the Madras District Police to the police in Calcutta's ports, all the way to the Assam Rifles. This law cast a very, very wide net across the entire colonial system. So, when you strip away all the legalese, all the sections and clauses, this act really boils down to one single, overarching obsession for the colonial government: making absolutely sure its police forces remained loyal and disciplined no matter what. And that kind of leaves us with one final thought to chew on. This is a law from a totally different time, built for a system of government that no longer exists. But it raises a question that feels surprisingly modern. What can a century-old law about police loyalty and dissent teach us about the complex relationship between the state, its security forces, and the public today?